criminal statutes of limitations are a bar to prosecution. I'm Tulsa attorney James Wirth, and that is the issue that we're dealing with here, statute of limitations in criminal cases and how they're treated. So in civil cases, typically a statute of limitations, you're not supposed to file if it's after that period of time, but that's not necessarily the case. In civil cases, it's been viewed as an affirmative defense. That means a plaintiff can file out of time, and it's incumbent on the defendant to raise the statute of limitations, and if properly raised, that can be grounds to dismiss the case, but if it's not raised, that it could potentially be waived. But what about in a criminal case? Does that deprive the prosecutor of the authority to prosecute, or is it on the defendant to determine that it's an issue and file a motion to dismiss? What triggers it? Well, there's a case that goes back to 2006, Cox v. State, 2006, OKCR 51, where the rule is talked about, and what it says: because a statute of limitation may operate as an absolute bar to prosecution that implicates at least the temporal jurisdictional limits of the power of a court to adjudicate a case, as well as the state's power to prosecute. Moreover, we will not presume a defendant waived the issue through silence or by failing to raise it in the trial court. So that is the precedent that we have. And then there's a more recent case that's what's bringing this up now, which is Starlin Sean Hill versus State of Oklahoma, C-2021-504, decided by the Oklahoma Court of Criminal Appeals on February 9th of 2023. And in that case, the state ultimately filed criminal charges outside of the statute of limitations. And then the defendant did not the defense, made some mistakes, apparently did not find that, did not make a motion to dismiss, did not address, and ultimately the defendant was convicted, and this is brought up on appeal. So the question is it too late for it to be brought up? We talked about the rule in civil cases, which is that it's an affirmative defense. It must be brought up by the defendant to do it. But in a criminal case, the court kind of walked the line. Now, if it is completely a jurisdictional bar, then that would mean that it could be raised at any time. The court lacks jurisdiction, and more importantly, that the defendant could never waive it. If it's a jurisdictional bar, the court lacks the authority. The defendant cannot give the court authority it doesn't have simply by waiving it. But they kind of muddied the water a little bit by saying that it at least implicates temporal jurisdictional limits, but that it can't be waived through silence. So what it's saying is it's this kind of middle ground, in that it doesn't completely deprive the court of jurisdiction, but it also can't be waived through silence. So ultimately in this case, the court found that the defendant did not waive the issue, even though it was not brought up until after the conviction, and it could be brought up for the first time on appeal, but they went short of saying that it's completely jurisdictional with this temporal language. But it can be raised at any time unless it was affirmatively waived by the defendant, which is unlikely to happen in any case. So in practice, it's pretty much a jurisdictional bar. It can be raised at any time. So if that's an issue that you're dealing with, need to raise it on appeal, or potentially you could even argue if it deprived the court of jurisdiction, could potentially be raised after an appeal, but we don't have a case on that yet. Nonetheless, if you're dealing with the circumstances related to criminal offense in the state of Oklahoma, you're going to want private, confidential advice specific to your circumstances. To get that from an attorney at my office, go online to makelaweasy.com.